Good afternoon, esteemed colleagues and members of the professional bodies herein represented. We're all warmly welcome once again to another session of a webinar on the platform of Association of Nigerian Chartered Architects. It's a delight to have you all in this conversation, in this most instructive, what I call most instructive conversation. The theme of the webinar being the architect and the laws of the Federal Republic of Nigeria, a guide to keeping out of trouble. I will have the guest speaker here with me, who is ready to do justice to the conversation. And also I have my co-host here with me. At the end of towards the tail end of the webinar, we'll be introducing those who have made this virtual conversation a success. First off, I just want to get the ground rolling with some housekeeping rules. I believe we are all acquainted with the format of always ensuring our mics are muted at all times, except we are requested to do otherwise by the moderator of the session. Also, kindly ensure that you use the electronic wave of the hand to get our attention and not speaking across the interface arbitrarily, just the electronic wave of the hand to signify our attention as may be required. Second off, to be able to enhance and have a sustainable bandwidth, we'll appreciate all videos are turned off. If you are not the guest speaker or the moderator, as it were, all videos, please, let's turn our videos off so that we can have a sustainable bandwidth to power the conversation to the very end. At this point, I want to introduce the chief host of the webinar. She is the Association of Nigerian Chartered Architects. This webinar is being powered on the platform of the Association of Nigerian Chartered Architects under the guidance of and the leadership of the national president, architect Emmanuel Noyo Omasoni, who is the chief host of this webinar. My name is Bodri Ogutoye. I'm the moderator of this webinar, the national PRO and media director of Association of Nigerian Chartered Architects. And we once again welcome you to a very most decisive, it's going to be a very decisive moment for us when we begin to look at the studies of legal issues, how it affects us as professionals, the implications. There's no way under 3 hours we're going to be able to. Please, like I earlier, Please, like I earlier said, if you are not the moderator or the guest speaker, please ensure your mics are muted. There is no reason for your mics to be unmuted. Please, let's adhere with the housekeeping guideline of the house. Thank you very much. Like I was saying, as it were, we are going to have it's looking like we're going to have a two-part conversation of this webinar series, as it were. Now, before we get the ground rolling, before we read the citation of the guest speaker, and of course, I believe we all know who the guest speaker is. I fondly call him the Asiwaju of architecture in Nigeria, no other than the MD, ASDEC ASC Consultants, Architect Ladipo Lewis, FNIA. He is the one who is going to do a very exhaustive work on this conversation. Before we do that, I'm just going to read a preface to a synopsis, as it were, for this conversation. That's the Architect and the Laws of the Federal Republic of Nigeria, a guide to keeping out of trouble. It goes, the practice of architecture is a fascinating and creative occupation. The passion expressed by its practitioners is always juxtaposed against the need to earn a living, which very often results in mistakes and errors being made knowingly and unknowingly, with the laws being contravened. The creative process of developing designs is always an exciting journey that the architect takes to fulfilling his desire to create and deliver a masterpiece. And the euphoria often overshadows the thin line between right and wrong. And he forgets that he does not operate in a bubble. In the environment which the architect operates is the client, who requires the building with the financial obligation to provide the funds for constructing the project and give it the legal backing to make it possible, which might involve financial institutions that he will borrow from and is obligated to pay back. The state government to provide approvals and regulatory conditions to build. The contractor who would execute the project with his workers and deliver the project on time. And the list goes, the requirements goes on. All these parties with the architect have to operate within the ambit of the laws of the Federal Republic of Nigeria. These laws directly and indirectly impact the architect in not just in the carrying out of his professional obligations, but in his very existence in society. There are various laws of the land that the architect needs to be wary of. We know court cases involving architects are not a commonplace in Nigeria, but disputes and claims of negligence are rampant. The architect needs to be very aware of the laws of the practice, contract, ethics, and code of conduct, how to avoid liabilities and unknowingly taking them on, as well as other laws of the land that are legal tripwires that can get the young architect in trouble. This presentation will run through various case files of practice scenarios rather than a rundown of the laws of the Federation to show how these laws can impact the architect in practice and form a guide to keeping out of trouble. It's much easier to stay out of trouble than to get out of trouble later. Ladies and gentlemen, there you have, there you have the foreword or the preface for this conversation. That gives you an insight into what the whole conversation, the direction of the conversation will be. I'm going to hand over from here to Francis Azubike, who's going to read, who's a co-host, one of my co-hosts, many co-hosts there, who is going to read the citation of our guest speaker, Architect Ladipo Lewis, before we bring him on. Thank you.
Thank you, Architect Ogutoye. Good afternoon, ladies and gentlemen. It's a great pleasure for me to read out the citation of our guest speaker this afternoon, who will be talking to us on how the laws of the Federal Republic of Nigeria affect the architects and how we can avoid some of the legal tripwires that can land him in trouble. An international associate of the American Institute of Architects, Architect Lewis is widely traveled. He has attended and delivered more than 40 lectures in various professional conferences in Nigeria and all around the world, including Italy, USA, UK, Japan, South Africa, Egypt, Ghana, India, Singapore, China, Dubai, Kenya, France, Abu Dhabi, and Malaysia, to mention but a few. He has toured more than 37 international historical and architectural buildings and undertaken more than 50 construction projects, with some major ones currently in progress. Architect Ladipo Lewis was the former secretary and chairman of the Nigerian Institute of Architects, Lagos State Chapter, from 2010 to 2012, and 2012 to 2016, respectively. He was a member of the International Affairs Committee and sat on the membership of the Institute's Education Board. Architect Lewis also served as a member of the Lagos State Housing Policy Review Committee. He is a director in Terraform Limited Development Company and Oluwole Urban Mall Properties Limited, developers of Oluwole Urban Mall, Lagos Island. He is an avid reader and he sits on the membership of ACONS, CPD, and education boards. Architect Ladipo Lewis is a fully registered and chartered architect. He is the principal partner of ASDEC ASC Design Consultants, a multidisciplinary design outfit, and ASDEC ASC Limited, a real estate development firm, both based in Lagos. He obtained his bachelor's and master's degrees in architecture from the prestigious University of Jos in 1988 and 1990, respectively, and was awarded a distinction for his master's design thesis project. Thank you all for your kind audience. My name is Francis Azubike.
Thank you, Francis. Well, now you have it there. You have the resume, the citation, the profile of our guest speaker. You know that we're going to have, from there, you can deduce that we're going to have a very rich and robust conversation this afternoon. Without further ado, I'll bring on and join me, make welcome the Asiwaju of Architecture in Nigeria, Architect Ladipo Lewis. You're welcome, sir.
Thank you very much. I'm a bit, will I say, shy, and I'm blushing here with the accolades being heaped on me by Architect Bodunri and Francis Azubike. I didn't know I had such a, will I say, a huge nickname. I'm not a title chief, but I think Bodunri is awarding chieftaincy titles now. So I would just like to thank the Association of Nigerian Chartered Architects for creating a platform for us to learn and rub minds together to better our practice of architecture. Let me give a little background to what brought me about looking at this topic. It's actually two-tier in a sense. When you look at the architect and the laws of the Federal Republic of Nigeria, okay, can you hear me? Can you hear me?
Yes, we
Yes.
can.
Yes. Okay. Yeah. So can you see my slides?
Just wave your hand.
You
Yes,
can
we
wave your
can.
hand if you can. Okay. Okay, thank you. As I was saying, this presentation is looking at actually a topic that I was dragged into by circumstances, and it involves a little bit of research into this area. You know, when you look at the laws of Federal Republic of Nigeria, you probably don't know much about it. I never knew much about it until circumstances led me to, oh, I need to know about this law. How does it affect me as a practicing architect? Now, this first part I'm looking at is about you generally. Areas that you might not look at, areas that even outside architecture, but who relate to your practice and your well-being and your standing as an architect in society. As an architect, as a professional, you might want to consider certain actions, but because you have a license, you can't behave like everybody else. So I want us to jump into, because we don't have a lot of slides to do. What I've done is I've put in as much data as possible, but I will explain them and be giving examples as we go along. As I've said before, keeping out of trouble is better than getting out of it. It's a lot easier. And then I want to give a warning. This seminar presentation is for information purposes only and does not constitute materials for making a legal opinion. Do not use information here as legal advice. Your situation will be unique. So please seek expert opinion and the service of a legal practitioner when dealing with legal matters. Because I'm not a lawyer, but I needed to be aware of these things because I had to be dealing with lawyers on various issues and various matters. And as they all say, you will rely on expert opinion, but you also need to be knowledgeable. I've come to find out that a lot of firms even have abroad have in-house lawyers. They have teams of lawyers. They have consultants. They have all kinds of people guiding them. As one of my friends said, he said in 12 years of practice in Austria, he had been sued 11 times. The introduction to what we've said is that architecture is fascinating. It's a creative occupation. You have a passion that's expressed by its practitioners, but it's just opposed against the need to earn a living at all costs. You will survive. And along this route, we make mistakes and errors, even personal ones, unknowingly we contravene laws of the land, you know, and these things affect us. We are more aware of the heinous crimes like murder, armed robbery, kidnapping, and rape. You hardly find architects, you know, being involved in such things. So we're not really aware about some issue areas, some things that come about changing facts, altering documents, which is actually forgery. See, and these all laws are interrelated, and there are state laws, there are federal laws, there are executive orders, there are different kinds of laws that you have to, even local government laws. But I will be dealing with the federal laws, and which is an overall body of all the other laws. And see, negligence and ignorance can also result in your complicity in a criminal or even civil suit. So the guide to keep you out of trouble is just to know the law and how it impacts your activities. I've shown some pictures of some 4 projects that I've actually had civil suits. Some of them relating to negligence, some of them, well, these ones really have any criminal intent in them. We will see those who have criminal intent and those that are civil as we go along. The second part we will deal with really the core practice and the running of the practice and how laws affect you. So let's do some definitions. As we go along in society, what is a bill, what's an act, what's law, what is thought, what is a bill? It is a draft of a proposed law that's presented to the House of Assembly. In Nigeria, we run a bicameral assembly. So a bill becomes an act after it's approved by the House of Assembly. A bill can propose a new law, or it can modify an existing one. And a bill can be changed compared to an act. So what is an act or law? An act is actually a law passed by the House of Assembly. An act is called a bill before it's approved. An act can create a new law, modify an existing one. And the process of changing an act is actually more cumbersome. So what is thought? Now, thought, we used to have it in the exam. It's considered a civil wrong that causes the claimant to suffer a loss or harm, resulting in legal liability for the person who commits a tortious act. It can include intentional infliction of emotional distress, negligence, financial loss, injury, invasion of privacy, and numerous other harms. As we go into the detail of the various laws, I will explain in how this affects you as an architect. But then before we go on, what is criminal and what is civil? Here are all the statements being made by lawyers. There was a civil case, the criminal case. Well, a crime is an offense against the state. That's the government, the people of Nigeria as a whole. Even if it affects an individual, it is prosecuted by the state. A key example of this is the case of murder. It's an offense against the state, but it affects an individual. Stealing, forgery, even defamation. So a criminal to attract a jail sentence and will result also in a civil prosecution. So if you stole money, you embezzled money, yes, it's a criminal offense. But the recovery of that money from you or from that person could be a civil case. Now, crimes include murder, fraud, assault, stealing, for destruction of property, so many of them that some of them we're not actually aware of. Some of them even affect our social lives in a sense. So a civil case then typically involves disputes between individuals regarding legal duties and responsibilities they owe one another. A lot of times our professional practice really falls under civil cases. But as we've said, it could also be criminal intent. So a form of rescission is always involved in a civil case. It can also result in criminal prosecution, also as I've said. Civil cases include debt recovery, contract disputes, trespass, divorce, tenancy, disagreements, and all agreements. You want to claim money, you are being owed fees. Those are civil cases. So you just want your recompense back. Of course, you charge an interest for the loss of revenue on the money, loss investment on it. Now, there was this, I noticed this while doing my research, that the state of Texas at one point in time decided that they had to fingerprint architects. That's how serious they took it. And I said, wow, in 2014, they went about fingerprinting architects. So they said, what happens if an architect is in good professional standing, is revealed to have a minor crime on his record due to being fingerprinted? Will he lose his license despite the quality of his work? Yes, it's possible. That's the truth. So this requirement, they said, will apply to just not new applicants, but also to licensed architects seeking to have their registrations renewed. And violators will face a fine of up to $5,000 per day in which they are not in compliance with this new law. Currently, only one other state, Massachusetts, even runs criminal background checks on architects. Now, Texas is upping the ante. So if you say practice in Nigeria is difficult, try Texas. Yeah, the Lone State Star is not a place you go and play around with. You will be fingerprinted, and you could be tracked all over the place. So in the laws of Nigeria, as you can see, we have the laws of the Federal Republic of Nigeria. You can generally see there is a constitution of the Federal Republic of Nigeria. There are treaties of Nigeria, there are court judgments, there are federal laws, there are laws of the states, there are rules of court, there are standards, there are regulations and guidelines, there are executive orders. Now, I will go into the laws of the Federation and mention a few of the others as we go along. It's listed A to Z, and there are quite a lot of them. So I would suggest you go to the link that is above the screen, and you can see quite a lot of them. And I will just run through them. Then we go to the ones we think would affect us. So under the laws, under A series, you have the schools, universities. There are laws that set them up, and various laws. In there, you can see advanced fee fraud that we know as 419. And then other related offenses, the amendment to it, you see advertising practitioners registration. There also you see all the other institutes, government institutes are set up by laws. So if you're dealing with them, you might also want to check out the laws that set them up as you go along. Under that also we have the Architects Registration Council of Nigeria. It's also under those laws, So in a sense, these laws set up all various arms of agencies of government, various departments of government, Asset Management Corporation of Nigeria Act. You see quite a lot of them. B series, you see universities, things like Bite or Bunny Act. There's so many of them. Casino Tax under C, Casino Taxation Act, Building Lines, Federal Trunk Routes. Even the Boy Scouts Act is there, So we have various centers for Black and African arts and civilization set up by an act, Chartered Institute of Management, Chartered Institute of Stockbrokers, Citizenship Leadership Center. So there are quite a lot of the C series. There we also see the Constitution under the C series as well, Corrupt Practice and Other Related Offenses Act. These acts are various acts affect us. Criminal Code is probably one of the most unique ones that we're going to look at here, and that affects us generally because it's probably one of the most, it covers a lot of things the others to cover. Some of these acts are even specializations of the Criminal Code. Customs, dangerous drugs, Debt Management Office, the Establishment Act, Education Tax Act, Electoral Amendment, just on E, Examination Malpractices Act. That affects you if you're sitting for a professional practice exam, and even if you're an examiner as well. Factories Act, working on a factory, you need to look at that. It will affect your design and your relationship with setting up such establishment. Federal Inland Revenue Service, Federal High Courts, you have all the acts under F series. You have the G, Gaming Machine, General Loan and Stock Act, Harmful Waste, Special Criminal Provisions Act. Under you have the Immigration Act. If you want to work with a foreign architect, you might need to look at that act as it affects your relationship to bringing him into Nigeria. Food and drugs related products, foreign exchange, Freedom of Information Act, under the F series, on the G, gaming machines, general loan and stock, harmful waste, hydrocarbon refineries, quite a lot of them. So these laws continue until you get to the last set of laws. Trademarks, wages, boards, water resources. So you can go online to check each and every one of them as you feel is relevant to whatever you're dealing with. Now, the actor is most time aware of violence and keeping from the heinous crimes, as I've said before. And those body on contract laws and agreements don't default on the contract. And of course, the Accreditation Council Act of Nigeria. And to some extent, the Code of Conduct and Ethics. But the border lays about the myriad of laws A to Z that we have seen in the laws of Nigeria and all that, local government laws and all that, except the police arrest you on the road, they stop you, you default on the traffic law and all that. Now, these laws are already in plain English, but sometimes we need to practically explain and understand the context. So I'm going to touch on the Constitution of the Federal Code of Nigeria, Criminal Code, and the Akon Act. And then I'll look at some case studies and how this could affect you as an architect. The Constitution, this is supreme. It actually should be a read for every person, every Nigerian citizen. And I can tell you, I never took it seriously until, you know, I had to look at an issue and I said, look, the only answer to that question was to go to the Constitution. So the Constitution is supreme. Its provisions shall have binding force on the authorities and persons throughout the Federal Republic of Nigeria. If any other law is inconsistent with the provision of this Constitution shall prevail. And that other law shall, to the extent of the inconsistency, be void. That's in Article 4.3. On Article 4.1, legislative powers of the Federal Republic of Nigeria shall be vested in the National Assembly for the Federation, which shall consist of the Senate and House of Representatives, which is a bicameral assembly, House of Assembly that we run. Now, the word that interested me, that I felt affected me as an architect, was every person shall be entitled to freedom of expression, including freedom to hold opinions and to receive and impart ideas and information without interference. You know, over the time we've been having issues in the architectural profession. This person joins this association, this person is part of the association. I was when I had to go and look at the Constitution. And this is Article 40. Every person shall be entitled to assembly freely and associate with other persons. And in particular, he may form or belong to any political party, trade union, or any other association for the protection of his interests. Section 42 says, prohibits discrimination on the grounds of place of origin, sex, religion, status, ethnic or linguistic association, or ties. And this embodies the concept that you cannot impose your will on someone else. They have the freedom to associate with whoever they deem fit, and you cannot restrict that. And the Constitution is supreme. You will find this Charter of Human Rights and Freedom, you know, of expression found all over the world. United Nations Charter, you know, human rights charters all over. And it could actually impact on you if you're found to have violated someone's constitutional rights. In fact, you have a lot of NGOs who enforce these constitutional rights on behalf of people it's infringed upon. And we need to be very careful about how we handle ourselves. In terms of employees, it's very key. In terms of people we work with, we cannot discriminate based on origin, sex, religion, status, ethnic or linguistic association or ties. And also even in terms of disability, if that disability does not stop that person executing the work you want to do, you can use that to discriminate against him. So the Constitution, if we observed it, we would probably not have seen a lot of the chaos and animosity we saw between associations. And I know you all understand what I'm talking about. Let me give this example of before I go to the area of the criminal code, which is I'm going to dwell on seriously and talk about, because it actually is probably the most serious. Others are serious because any federal law is a crime. You know, it's a crime against the state. Now, the British architect John Purcell caused an uproar in 1970 when it was revealed that he had been bribing public figures. He was arrested in 1973 on corruption charges, and his 52-day-long trial cost £1.25 million. He was sentenced to 5 years in prison and later pled guilty to 9 additional charges of corruption and conspiracy, which added 2 more years to his sentence. 2 others were jailed. The Home Secretary, Regina Murray, was forced to resign. Over 300 people were implicated in the affair. You can see John Purcell's building, the Canal Street Station, the frontage of the Leeds International Pool, City House in 2008 before it's reclining, an entrance to Pontycraft Library. But it was involved in a lot of things that we'll find in the criminal code. And you to kill for it. Another well-known architect at a point in the news, he became popular, was Henry Patrick de Villiers. He actually had a good time with the Chinese politician Bo Xilai and his wife Gu Kenlai. And he was doing projects for them in China. But they had, would I say they had unclean hands, and they used some British businessman in Hayward, they were fixers, they did things for them. Unfortunately, Haywood was found dead in a China hotel in 2011. And who was charged with murder, and the witness had to be a witness. So, in a sense, he was just acting as an architect, but for the wrong person. And that was why he was actually remanded in China. You know, he had to go willingly to China to go and address this issue and become a witness. It ended up in the news, and it really affected his career. So, by association, by who you do business with, the laws will actually impact you. So, the criminal code, it has over 521 sections. So I had to go through it at a particular point in time when I said looking at the laws of the land, and I'm going to just talk about some areas here, which I hope when we look at the slides, you can go back and just go online and look at the criminal code. Now, people do not sometimes realize and attempt to commit an offense, social offense. So when a person intending to commit an offense begins to put his intention to action by means of adultery and manifest decision by some overtime, but does not fulfill it, to such as common offense, he's said to attempt to commit an offense, and that's also crime. There are principal offenders. You know, every person actually does the act or makes omission which constitutes the offense. Every person who does or commits or to do any act for the purpose of enabling or aiding another person to commit an offense. Every person with another person committing the offense. Any person who counsels or procures another person to commit an offense. So you have to worry about your participation in any activity. Then there are accessories after the fact. I'll look at this in detail. The person who receives or assists another either was part to it or had knowledge of it. So it's the ignorance of the law is not an excuse for any act of omission, which would otherwise constitute an offense unless knowledge of the law by that offender is actually declared to be an element of the offense. So you have to be careful that you're not ignorant. Publication of false news with intent to cause fear and harm, cause fear and alarm to the public. Be very careful. I see that people posting things online that could incite people. You get a video. It's not about Nigeria, but it's written about a part of Nigeria. Some set of people are, assaulting other people, and it is false. It will incite fear and harm. Some people fabricate stories to create rumors that could incite people and create panic. You should be careful about distributing such information because it's actually a criminal offense. There is also the definition of an unlawful assembly or riot, when three or more persons intend to carry out some common purpose, assemble in such a manner, or being assembled, conduct the same such a manner as to cause person able to an unreasonable manner that the person's fear so assembled will automatically disturb the peace. You need to be careful. I've been to a meeting where it practically became a riot. Everybody was shouting and pushing each other. People locked the doors and were trying to stop people, and somebody was videoing it. So it could turn into an unlawful assembly, even if the assembly originally was lawful. He says it's immaterial that original assembly was lawful. If being assembled, conduct yourself with a common purpose in such a manner as aforesaid. So you could start a meeting lawfully, and while undertaking it, it turns into a riotous situation. You are in danger of being labeled to have caused a riot. Forcible entry. Any person who in any manner likely to cause a breach of the peace or simple application of a breach of the peace enters on land, which is an actual and peaceful possession of another, is guilty of misdemeanor. So as an architect, you need to be careful. So likelihood of an imprisonment for 1 year. You can't forcibly enter a site. You need to be careful. A client will tell you, oh, I have this plot. You only need to do is there's a padlock, break it. Be very careful. You could be forcibly entering someone else's site without knowing it. So what do? you know that the law is there. So you get a little written letter. You ask your client to give you peaceable entry into the site, because you're breaking it would actually be a breach. So these laws of forcibly entering a building, forcibly entering a site, will actually be, it says it's a misdemeanor. You probably get, 1 year. That's why you call it a misdemeanor, because 1 year. You're not getting 3 years, 7 years, or 15 years, or a life sentence for such an action. But it's still a sentence. I don't think anybody wants to spend a day in prison. So anarfree, what is that? Any person who takes part in a fight in a public space is guilty of misdemeanor, and is liable to imprisonment for 1 year. So be careful of physically fighting in public space, even at home. You consider to be an assault. Look at what assault is. Threatening violence. You cannot intimidate people. With intent to intimidate or annoy a person, threatens to break, commits any other breach of the peace, you are guilty of a misdemeanor. And this misdemeanor attracts 3 years. And 7, for the purpose of smuggling, be careful. You might want to buy goods. You might want to use goods on your product. If they are smuggled, you could be facing a fine or an imprisonment of 6 months if you are accused of smuggling. Yes, we need a lot of things that are smuggled in Nigeria. Everybody turns the eye the other way, but you also need to be very careful, because you might not be so lucky. Official corruption, public official inviting bribes. These are for those of us who are in public office. Extortion by public officers. You should know that certain things can be used against you, and their crimes against the state. So also public officers interested, in projects, persons, who's or directly otherwise, contracts and things like that, or being employed in projects, only acquires or holds or directly or otherwise done as registered stock company, also more than 20 persons. What this is saying is that you as a public officer, you cannot be involved in contracts except you're investing in a stock company. I know this is a rule that doesn't apply in Nigeria a lot of times, but it could be used against you, and you are liable to 3 years imprisonment for that, fine at discretion of the court. False certificates by public officers. Any person who being authorized or required by law to give any certificate, touch any matter by virtue of whereof the rights of any person may be usually affected, gives a certificate, which to his knowledge is false in any material particular, is guilty of a felony and is liable to imprisonment for 3 years. So you have to be careful about false documents, fake documents, and you need to be careful about. So as an architect, if you are in prison, you're obviously going to lose your license. You can check that in the Akon Act. If you are incriminated in a crime and you go to court and you are found guilty, you will lose your license. We will look at that as we look at it in the Akon Act. So all these things I iterate have said. Punishment for perjury. Perjury is when you lie under oath. It's so serious that it says if any person commits perjury is liable to imprisonment for 14 years. If the offender commits the offense in order to procure the commission of another person for an offense punishable with death or with prison for life, is liable to imprisonment for life. So you need to be careful about perjury, lying on the oath, lying on documents, fabricating evidence. Any person who with intent to mislead the entry or any judicial president fabricates evidence. This is also a criminal offense. I would say this, that preparing for your professional exams, you have to be careful about section 118 and section 120, because all the documents you bring in must not be fabrications, and you must not lie. Because you actually sign a disclaimer that all the things you're presenting were carried out by you. Your supervisor also signs that you supervised your work. So these two sections could affect you. corruption of witnesses. Now, you cannot corrupt a witness, you cannot influence someone, you cannot deceive a witness to, to change his testimony. You cannot destroy evidence. And you must be sure that whatever you're presenting is factual. Now, you would see this among even architects and candidates who face the architects investigation panel. So if you are invited to that panel, please make sure you are not allowed to do anything that will contravene sections 121, 122, or 123. Conspiracy to bring false accusation. I see a lot of this when architects have disputes among themselves, and you see people making false accusations, fabricating stories, and actually putting them in print and sending them around. This is a criminal offense and is liable to imprisonment for 14 years. So making a false accusation, you have to be sure of your facts. Do not fall into this trap. I saw this picture online and says even a fish will stay out of trouble if it just learn to keep its mouth shut. And I said, wow, interesting. Sometimes we just need to just watch what we say, what we do, and be careful about the words we utter. The previous sections, we probably won't fall into them if we kept our mouth shut and we are careful about what we say. So, perverting justice. Any person who conspires with another to obstruct, prevent, or pervert, or defeat the cause of justice is guilty of felony and is liable to imprisonment. I was really shocked about this when I saw it. I was asking myself, and it's 7 years. And this is the offender cannot be arrested without a warrant. It means that he has to be investigated. A court warrant has to be issued to the police to pick him up. So this code, it shows that look, you cannot influence proceedings. A case is being investigated, you cannot conspire to obstruct it or prevent it. Bringing fictitious action on a penal code, penal act, law, or statute. So you cannot bring fictitious claims. You cannot falsely accuse someone. And that's also you're guilty of misdemeanor and liable to imprisonment for 2 years. It's also contempt of court. You have to be, if you ever have to give witness statements or anything in court as an architect, which I've had to do once or twice, it says you have to do it with respect. You cannot show disrespect in your speech and your manner. You cannot be, abusive or loud or, disobedient or misbehave during such proceedings. And you cannot refuse to attend or refuse to be sworn or to make an affirmation. And having been sworn to, you are obligated to answer questions and to produce any document that is required. If you're found guilty, this offense is liable to imprisonment of 3 months. So that's why I say it's a simple offense. Now, obstructing officers of courts of justice, you cannot do that. You cannot, disobey the execution of another warrant of any court. If you ever issued a warrant, invited to a police station or invited to court, you're obligated to attend. You're obligated to show yourself. You can go there with your lawyer. But we're fully obstructing it. You land it in imprisonment for 1 year, or as they say, a fine of 200 naira. And I'm sure some of these fines will change as time goes on. Resisting public officers. You have to be careful about this too as well. You see people in the public space fighting with policemen, security men. I've had to discipline a staff once who engaged a security man and said, do you know the implication? And unfortunately, the staff ended up in the police station. What was the argument over? Parking space. And this staff allowed our spouse to kind of escalate the situation until it became an issue where they were arrested. And, you know, you have to be careful about that as an architect. So your behavior is paramount here, and you're liable to imprisonment for 2 years if you are resisting public officers. Offering violence to officiating ministers of religion, that you also have to be careful about. So you might be part of the family proceedings, family disputes. As an architect, be very careful. So if you make a threat, maybe at the wedding, the family has a dispute, excuse yourself, because you are the one that has a license. Minister, you as the architect need to be careful, because if anything happens and you are convicted, not a problem, but you, the architect, will lose your license after even going to prison. Common nuisances cannot obstruct the highway. Yes, during our construction work and things like that, that is also a criminal offense. You'll be guilty of misdemeanor, blocking the highway, you know, that could also result in injury, you know, preventing public access on the highway. You need to, if you need to use a street, you need to get permission of the government to do it. Whether it's the local government or the state government or the federal government, or whatever that road is, you simply cannot just obstruct the road and feel that, oh, your construction demands the requirement of that space. You'll be guilty of a misdemeanor and you are liable to imprisonment for 2 years. Definition of assault. A person who strikes or touches or moves or otherwise applies force, any kind to the person of another, either directly or indirectly, without his consent, or with his consent, if the consent is obtained by fraud, or by anybody act or guess or attempts or threats to apply force for any kind of person of another without it's such as that person making the attempt or threat has actually or apparently a present ability to effect his purpose. He's said to assault that other person, and the act is called an assault. So you cannot just lay hands on anybody. You can defend yourself, yes, but you cannot. If you went after somebody for whatever reason, it could be defined as assault. So you need to also be very careful about that. So avoid any confrontation, physical altercations that will land you having committed a criminal offense. Exercise of right of way or easement, yes. So if a person is lawfully entitled to enter upon a land for the exercise of the right of way, you cannot stop them. You can't block them. You can't stop them from entering. It's also a criminal offense. Now, section 370 is defamation, definition of defamatory matter. What is a defamatory matter? On our social media platforms, you see a lot of people writing a lot of things. So defamation is a matter likely to injure the reputation of a person by exposing him to hatred, contempt, or ridicule, or likely to damage any person in his profession or trade by any injury to his reputation. Such a matter may be expressed in spoken words or in audible words, or in words legible, marked on any substance, whatever any sign or text, by such a matter otherwise than by words. Now, what it's saying is that you cannot defame a person. You cannot say untruths about the person. You cannot put it into publication. You know, and publication of a defamatory matter is liable to imprisonment of 2 years. So you have to be careful about what you write. If it's found to be a lie, it is going to be considered a defamatory act. So publication of truth for public benefit. Yes, the answer to the previous one says The publication of defamatory matter is not an offense if the publication is at the time it is made for the public. I mean, if defamatory matter is true. So if you made a statement about, I say, a matter of fact, exposing something, it is not considered a defamatory matter. So you must be able to prove that. But I would advise you, if you have an issue and someone has done something wrong, go to the police. Rather than social media or making publications, go to court. Go to the police and report, it becomes a criminal case. If you go to court, it becomes a civil case. Rather than going on social media to make such statements, you could be accused of defamation. Stealing, things capable of being stolen, it basically says anything that is not yours that you move is stolen. It doesn't belong to you. You transferred it. You took it without permission. You are not supposed to take it. It's stealing. So that's the definition of stealing. You fraudulently take anything capable of being stolen, fraudulently convert it to your own use or any other person's use. Any person who takes or converts anything capable of being stolen is deemed to be so fraudulent. So these are things that we have to be careful about, especially as architects. The material belongs to a client, it's not yours. Moving it out could be considered to be stealing. So you need express permission, it has to be yours. As an architect, you can't really just move anything. So you need to be careful about that. So these are things that could impact you as well. So that's the definition of stealing. Now, taking or commercial may be fraudulent, even if it's not in secret. That means even if you did it without considering it, you did it openly, it is considered fraudulent. So you could actually carry out an act that is fraudulent in public and even get people to be involved in it. That means you could do it, you could open. Now, yes, we are taking this thing away. Yes, but because it doesn't belong to you and you don't have the power to move it, you don't have the power to dispose of it, it becomes stealing. If you are told you cannot dispose of this material, you cannot take out this material, you cannot use it for your purpose, it's considered stealing. And what's the punishment for stealing? It's imprisonment for 3 years. So if you're working on a project, you need to be sure that leftover materials, leftover this, you have the authority to take them. If not, you could be charged for stealing. Now, fraud on sale or mortgage of property. If you went to sell somebody's property and you don't have the authority, or you falsify any document or any title to do it, it's considered fraud. Obtaining registration by false pretense. When you are registering as an architect, you're registering to do an exam, you need to be careful about false pretense. Anything you're putting should be fact. You'll be guilty of a misdemeanor and you are liable to imprisonment for 1 year. Now, receiving stolen property. Everybody knows that, look, the last thing you ever want is to be involved with a stolen vehicle, but any other thing that is stolen too is also stolen property. And is considered a felony or a misdemeanor. So you will be guilty of that as well. Now, trustees currently disposing of trust property. I'll talk about this because there was an issue I know about an association where a set of people decided to dispose of an asset of the association, and they didn't have authority to do it. So in this section 434 says any person who being a trustee of any property destroys the property with intent to converts property to any use unauthorized by the trust is guilty of a felony and is liable to imprisonment for 7 years. So if you don't have authority to dispose of something, you will go to jail for 7 years. The offender cannot be arrested without a warrant. So it has to go to a procedure of you filing a complaint is filed, police do an investigation, they get a warrant from the court to arrest the person. Now, if civil proceedings have been taken against a trustee in respect of any act done by him, which is an offense under the provision of the section, he cannot, after all, be prosecuted for the same cause as for an offense on the complaint of the person by whom the civil proceedings were taken, without the sanction of the court or judge, before whom the civil proceedings were had or appended. For the purpose of this section, the term trustee includes the following persons and no others: trustees upon express trust created by the deed, will, or instrument in writing, whether for a public or private or charitable purpose. This year, the trustees appointed by another authority of any act, law, or statute by any such person, purpose, persons upon which whom the duty of any such trust as of said involve executors and administrators. What he said is your exco or trustees need to know their rights according to the law. If they don't have authority to do something, then if they do it, it's considered fraudulent. Malicious injuries in general. Any person who if it destroys or damages any property is guilty of an offense. I had a case of something like this where someone was asked to move out of the building and he removed the roof. Now, this is a misdemeanor. So you are liable. So you are liable to imprisonment for 2 years if you do that to any property. So you have to be careful. I've seen some people who remove things when they are leaving buildings. Such an act would land you in trouble. Removing boundary marks with intent to defraud. Yes, you probably would not want to be involved in that, but when it comes to developing properties, you need to be careful about the boundary marks. You need to be careful about damage to beacons and things like that. They are serious matters. You cannot deface survey marks or boundary marks that taking their serious offenses. So you could, face a criminal prosecution for that. Forgery. For what are the definitions? A document or writing said to be false in the case of a document which is a written record kept by lawful authority, or any entry or any surface or which purportedly issued by the lawful authority, as certifying to the contents of any registered record kept by a lawful authority, or as testifying to any facts or events if any matter particular stated in the document is untrue. It's particularly saying that you cannot falsify information on any document, either in part or whatever form in its content. Those things you cannot, whether format it is, you need to be precisely sure that what you're written there is the truth. If it says in the document right is made in the name of an existing person, either by that person himself or by associate, with the further intention that it should pass as being made by some person, real or fictitious, or that the person who makes it or tries it to be made. That means you can't fabricate unknown people. You simply create phantom people, put their signatures, create a signature, create a name. It's an offense. And I've seen that being done by people, where the names and signatures are fake. They are not of real people, but they use it to produce a document. So that is considered a forgery. So whatever you're doing, make sure that you have the facts there. So in further definitions of forgery, you will see that it goes on to talk about the documentation must be genuine. You must refrain from the act of using a forged document. You can't make a counterfeit seal or mark. We've heard of seals being falsified. Akon seals being falsified. These are criminal offenses. Using a seal that is forged is a criminal offense. So even going to someone to say, seal this document for me, and that seal was forged, makes you an accessory to it. So you cannot remove, obliterate, change a document. And we see people doing it. You want to change the date on the document, or to change it, that is already a fact. You cannot. A genuine document cannot be manufactured again. You can't repurpose a document. You processed an API certificate for a project, and then you refabricated it for another project. It's a forgery. You cannot do that. You have to be very, very careful about this thing. We know a lot of people are doing it. and they seem to be getting away with it, but it could backfire one day. Yes, and it's a criminal offense. These gentlemen were supposed to be engineers, and unfortunately for them, they were caught. And the two of them are going to spend 257, who face 257 years in prison. They were both engineers, and one was an architectural designer at Palos Verdes Engineering. The other, and neither of them worked for licensed architects or civil engineers, but they were involved in over 700 residential and commercial properties where fraud allegedly occurred in more than 50 cities in Southern California. So if convicted as charged, one of them will face 152 years in the state prison, the other possibly a maximum sentence of 105 years. That's in California. The two are facing 487 counts. You see, when you talk of counts, it's like it could be forgery, it could be fraud, it could be or criminal negligence. A lot of the cases will involve more than one act. So you need to be careful, and it will pile up the sentences. And some of these sentences, they will not run concurrently. They will run after the other. So you could end up with a long sentence without knowing it. So punishment for forgery, that is an imprisonment for 3 years. Impersonation is an imprisonment for 14 years. I have heard of a case where someone impersonated someone for an exam, and he was caught. And that's even a professional licensure exam. So be very, very careful. So impersonation of a person named a testimonial or a card. Any person who, with the purpose of obtaining any employment or has any document of the nature of a testimonial or character given to another person is guilty of misdemeanor, is able to imprisonment for 1 year. You need to be careful about this. Lending testimonial for impersonation, even when you want to sell a document, and you lend somebody a document with intent to alter such a document, even to obtain a patient, you are guilty of a misdemeanor, and you are liable to imprisonment for 3 years. I noticed my slides are a bit distorted. I think the system, but I think I'll correct it later. Attempt to procure commission of criminal acts. You cannot procure a criminal act. You cannot send somebody to do something. You cannot send somebody to do something that is wrong. You send your staff, you send your security man, you send this to do something that is wrong. It's also an offense and it's punishable. Neglect to prevent a felony. Every person knows that a person decides to commit or is committing a felony, fails to use all reasonable means to prevent the commission of corruption that is guilty of a misdemeanor and is liable to imprisonment for 2 years. So you need, if you can prevent a crime, you are supposed to. So what's a felony? A felony is typically defined as a crime punishable by a time of imprisonment of 1 year or more. Misdemeanors are often defined as offenses punishable by fines or by short terms of imprisonment in jail. So the lesser crimes are known as misdemeanors. The bigger ones with more jail time are called felonies. So an accessory is a person who assists in but does not actually participate in the commission of a crime. So an accessory after the fact, someone who assists. Someone who has committed a crime after the person has committed the crime. 3, with knowledge that the person committed the crime. And 4, with intent to help the person to avoid arrest or punishment. An accessory after the fact may be held liable, among other things, obstruction of justice. An accessory for the fact is a person who aids, abets, and encourages another to commit a crime, or who is not present at the scene. So these are things you need to be careful about. You shouldn't be seen to be helping the person to do what is wrong, either for registration, for the exams, for licensure, for whatever, for processing, documentation, for registering. be careful about being an accessory. It's particularly important that we understand the processes of the law. And a lot of times, these laws are key to us understanding how we operate in society. And I always tell people that it's very, very important that you understand the various aspects of the law. You don't have to be a lawyer, but at least you know the basics, you know. Now, I'm going to I've passed through basically this part of the criminal code. So I'll look at the Akon Act, then I'll look at some case studies and examples of how the Akon Act is related to the criminal code and how they affect each other. There are a lot of parts of the criminal code that I felt were not relevant to an architect in a sense, but you could go over it in your own time, look at it as you, it doesn't hurt for you to know what you shouldn't be caught with and what you should avoid. And as I've said, there are about 521 of them. So, but under the Akon Act, the basic is this. This act is for the registration of the profession of the architects by the Accreditation Council of Nigeria and for all the matters connected with that profession. When a profession is protected by an act, it means that it becomes a criminal offense if you commit any infraction of that act. It's not civil, it's criminal. So it could be a misdemeanor, so it's a short jail time, and it could be something much more than that. Now, this is an infraction that we see all over the place, the use of the appellation of architect. It says in section 1, subject to provision of this act, a person shall not prepare or take full responsibility for the erection or commissioning of architectural building plans or practice or carry on business, other than that having relevance to ship possession, to landscape or golf links or any other name, style or title containing the word architect, unless it's a Nigerian state and registered under this act. It simply says you cannot call yourself an architect if you're not a registered architect under this act, if your name is not on the register. For your name to be on the register, you know you have to have certain qualifications. You need to have, passed the licensure process and been inducted and given a certificate that you are and can be called an architect. So this law applies to practically every country in the world. The architectural profession is a protected profession. But why is it protected? It's protected because of public safety. Yes, it's protected because of public safety. So it's like a driver's license. If you had a driver's license, you're protecting the public. And the public is, the safety of the public is important. So what establishes this, the establishment of the Architects Registration Council of Nigeria, there shall be established a body to be known as Architects Registration Council of Nigeria. This are referred to as the council, which shall be a body corporate by the name of and shall be charged with the general duty of determining what standards of knowledge and skill to be attained by persons seeking to become members of the architectural profession. This are referred to as a profession, and raising these standards from time to time as circumstances may permit. Securing accordance with the provision of this act, the establishment and maintenance of the register of persons entitled to practice the profession, and the production from time to time of list of those persons performing the other functions conferred on the council by this act. This empowers this council to determine A, B, and C, which is long, covers a lot of things. And I always tell people that we architects simply don't read the law. I also tell myself too that when did I start reading these laws in detail? For a long time, we don't bother to read the minute detail of these laws. And it's good that we are looking at these things and trying to understand it. We would save ourselves a lot of aggravation if we knew what these things, what the law says. Now, what's this register? It says it shall be to the register to pay and maintain in accordance with rules made by the contrary section. The register of names and addresses and approved qualifications as such. Other persons have been specified for all persons who are entitled in accordance with the provision of this act to be registered as architects, who apply in specified manner to be so registered. The register with particulars of architectural firms eligible to practice under the provision of this act. I looked at this part of the law, and you can see that your register must contain addresses and approved qualifications. And other particulars that will be specified. It becomes key then that whatever qualifications you present must meet certain minimum standards, must meet certain minimum requirements for the purpose of being registered. So you are not a nameless architect. You are an architect who has its particulars in place in a register, which is a public document for the protection of the public. So, and it also says a register with particulars architectural firms eligible to practice under the provisions of this act. So there is also a register of architectural firms. And that means only those people who are under that register can practice as architectural firms. So the law is explicit. We see developers, almost pretending to be architectural firms. This law shows that they are contravening it. There's also the issue of, if you're not an architectural firm, can you produce drawings and send them for approval? Obviously, this law says you cannot. So we all as architects have to see how we're going to use these laws to protect the profession, which a lot of people talk about. But they forget that it's also our duty. It's our duty as professionals to also look out for people who are in a contravention of this and report it. Now, this professional discipline is a section I've picked up here. There shall be establishment of a disparity tribunal and investigation panel. And there's this tribunal, the Architects Disparity Tribunal, that investigates infractions. And those infractions involve where they will look at the criminal investigation of whatever you've done. Whether it's criminal, it's civil, you could end up in front of the Disparity Tribunal and investigation panel of ACOM. So committing an offense would be a problem that could land you in front of that panel. What are the penalties for professional conduct? So, the person fully understands is convicted by any court. That was why I went into the issues of the criminal code. It says here if you are convicted, or else we are having power to award imprisonment of an offense, whether or not an offense punishable with imprisonment. So it means that if you are convicted of an offense, whether you went to jail or you are not, that is whether or not an offense punishable with imprisonment, which in the opinion of government is incompatible with the status of an architect, or a person professionally registered under that is likewise so committed in circles that the council decided that his name ought to be removed from register, or the tribunal decided that the name of any person has been fraudulently fully operational registered, which may, if he thinks to give a direction, reprimand that person if fully registered or whether or not fully registered, suspending that person from practice by ordering him not to engage in practice as an architect for such that not existing to reformers, or ordering the register to strike his name off the relevant part of the register. So your name will be struck off if you are convicted by any court in Nigeria. Or if we have no power to award imprisonment of an offense, or whether or not an offense punishable with imprisonment. This is why I went into the issues of the criminal code, the constitution, and there are some other laws, advanced fee fraud, and other laws that people contravene. This will be the penalty for such professional conduct if you are found. These offenses now, under Section 40, any person not being an architect or ceasing to be entitled to full rationalized who for or in expectation of a reward, practice or hold himself out to practice as such, or without reasonable excuse takes or uses any name, title, or audition or description implying that he is authorized by law to practice as an architect, shall be guilty of an offense. Subject as well any personal appropriation is who for in expectation of a reward, practice or hold himself out as authorized to practice other than as permitted in third schedule or third schedule without reasonable excuse, takes or uses any name, title, addition, or description implying that he is authorized by law to practice other than as is prescribed shall be guilty of an offense. Any person or of spoken relation of any name, qualification, or other matter makes a statement which he believes to be false in a material particular, or B, recklessly makes a statement which is false in a material particular, he shall be guilty of an offense. So this basically says that if your provision registered, you know you can only practice under a principal. You cannot claim to be a principal. So all these are offenses under this act. Now, I want to go and look at professional practice case studies, which will take all the other laws that we've looked at to consider.
Dear participants, please just hold a bit. I want to get our guest speaker back online again. Trying to get him back online. Okay, I think I hear you. You are off. You're off. You're not in the meeting room. Just please kindly give us some few minutes. We'll get back to you. Just hold on. Okay, sorry for that slight delay. Our guest speaker is back. I guess we just take this interlude as a short break. Quickly just stretch your leg, stretch your legs, your body so that the blood circulation can continue. Just it's not healthy sitting for too long. Just stretch your legs and move around a bit. Okay. Okay, his screen, his slides is back on. I saw someone's comment in the chat box said this plenty offense. Well, that it comes with the territory. That's what professionalism is all about. We are guided by rules, set of rules, principle, guidelines, laws. So we can't just live anyhow and relate anyhow and practice anyhow. Yeah, we need to be guided as professionals. Architect Ladi, are you ready, sir? I think you're back. Okay, you can go on, sir. Thank you. Please, can you still hear us from that side of the device where you are? Just with the electronic wave of the hand, kindly signify if you can hear us from this side and the co-host so he can continue with the lecture, please. Anybody in the meeting room, just a wave, electronic wave of the hand. Okay, thank you. Thank you, Rotimi Ajay, Peter Man. Thank you. Okay, sir, you can continue. Thank you. You can lower your hands now. Thank you. Thank you very much. So, this is
Sir, we can't hear his audio.
okay. We're at that point of technical glitches again. Just please, let's just sort out the guest speaker's audio device. A bit of patience and we'll see what the challenge may be just in a bit. Thank you. Just kindly be patient with us. We're trying to sort out the audio of our guest speaker. Okay. Ladi, can you talk? Let me see whether my.
Hello. Can you hear me? Yes.
Ask if they can hear you.
Can you hear me?
Please, if you can hear Architect Ladi's voice,
Yeah.
first of hold on. If you can hear Architect, no, please mute your mic. Just with the electronic wave of the hand, please just signify.
Can you hear me? Hello.
Okay, thank you. Thank you. We can use my own device. You can go on. We'll throw for my own device. You can go on.
Okay. So you can hear me now. So this gentleman worked for a firm, and he ended up facing a sentence for having participated in a fraudulent act by his employers, lawyers. And his case was an issue of his work being used to fraud. So we also need to be careful about your drawings, your designs being used to be fraudulent. I think it's one that's very important. We are in the era of a lot of real estate projects, and examples are current projects that are going on. Finding out that particular drawings have been used, they can't be traced, you don't know where they came from, and one is surprised at the quality of work that was done on them. Just have to be careful, even as a student, the student work will be used to be fraud, will be used to perpetrate fraud, and you will be held responsible because you provided the material for that act. So he now faces 14 months of suspended prison sentence. I want to see how going to start. That's because it's in the UK. In Nigeria, his punishment will be much more just. Now, there was this case of the Japanese building scandal in and Tokyo Skyline. He said the scandal was brought in because he saw that the article sell data had been fabricated in possession of drawings of hotels and buildings. And an architect in the social area was found by the program to find data since 1996. He sentenced to 6 years in prison and fined 1.8 million. And several bills had been turned down as a result of the scandal. And the architect's certification law was revised. So he must have been involved in documentation. So you have to be careful. You see architects taking up projects where you know very well that the soil test was not carried out, the soil test was produced, the soil test report was produced. A lot of these soil test reports sometimes are fabricated. You need to be sure that the documentation is authentic. And you're not involved in falsifying documents. I have seen where someone has falsified the survey plan, and that is criminal offense. And it's a forgery, it's criminal offense. So you need to be very careful about documentation. There's also a case of a fake architect or fintech.
Go on. Okay, the audio is echoing. You can put your own to mute your own and put it to 0. Mute your mic. Okay, let me mute your mic. Okay, go on.
So, a person who's a fake architect who was convicted by making false claims on LinkedIn, and I've seen a lot of LinkedIn posts from recent, quite a lot of them. In the UK, it's a criminal offense, and it's also in Nigeria. If you're not a registered architect, you're not a licensed architect, you now post such information on LinkedIn. that you are one, signing buildings, you are claiming to be an act. It's actually a criminal offense under the Act of Act. You could also be charged for impersonation, claiming to be what you are not. So these criminal charges will pile up depending on what you are claimed to be. So he quickly went and said he was not the one that made the LinkedIn platform, and ultimately pleaded and said that the judge understood that he was an idiot. And when he got off lightly, probably because he had not executed any project with the LinkedIn information or deceived anybody. But it tells you that you cannot go on social media claiming to be what you are not. It's also a criminal offense. There is a very popular case in the US called Operation Bandit Industries. Paul Gilliman had a successful and award-winning career at Detroit, New York, but there was one problem. He wasn't a licensed architect. In 2017, the University Attorney General and Schreiber indicted him on 58 counts following a 2-year investigation into Operation Bandit Industries. A note to Judge Constanza, for those of you who were signed to Judge Constanza is one of the actors there, and
I hope we haven't passed him on the road.
So Newman pleaded guilty to 6 counts and was sentenced to 2.5 to 7 years in prison. Now, what he's saying is this, that he may have been operating without a license. Actually, the fact now is and we have under the Alcohol Act, there are charges that could be brought against you if you're not a registered activist. That's what the law says. It's not anybody's personal interest to wrongfully accuse anybody. That's what the law of the land says. And until that law is changed, you are bound to abide by it. There are a lot of cases in the area of the UK that I'm using as case studies. Architect GWI, I'm hiding their names. In 2020, nature of the offense was about acceptable professional conduct, and issued a practical commission certificate that incorrect and fabricated issue in that commission. It is forgery. He knew that the issue based on understanding were incorrect. Issued a practical commission when he was not party to any contract relation to the building. His actions lacking any kind of response. He was not party to that and just issued certificates. Whatever purpose is penalty, but the 2,500 counts as a penalty. But it was considered an acceptable professional conduct. I'm sure I got away lightly because those fabricated data provisions were also forgeries. So lots of them were charged for criminal felony acts as well.
Which means we pass him
So
on
you
the
cannot
road.
just issue documents, produce documents for projects that you are not involved with. You could be charged.
It was like a flash. We're trying it by the progress.
Mr. Tudor FOA in 20 September 1820. Nature of the offense was a criminal offense. It was convicted of a criminal offense other than an offense as any material relevant to his fitness to practice that he was convicted on 29 November 2019 of breaching the restraining order imposed by the University of London. This had nothing to do with that. He breached the Harassment Act, and his penalty was erasure from the register. So he was convicted of the criminal offense, and once you're convicted of the criminal offense, same thing applies in the Alcohol Act. You will be removed from the register. Architect John W. Also, nature of his offense, he was sent a letter to the complaints dated 18 March that was it was an appointment that he sought to persuade and to intimidate the complainants into withdrawing their complaints. They are contrary standard 9.2, 9.5 of the architecture. Penalty, power part of that. You cannot persuade people to intimidate them or whatever purpose from reporting the matter And some people believe that they could do that. They could challenge you to withdraw a case, to withdraw reporting an offense. That's actually do that. It's actually inappropriate. That's in the since it was reported to the ARB, dealt with it. But it could also have made a complaint to civil court of that, and got another sentence on him, civil court as well. And the sentence was deletion. So he posted false reviews. Maybe projects he did not do. Maybe he posted, false information about his activities. And because he acted dishonestly and without identity, he was removed from the register. Architect Mr. David, nature of criminal offense was a criminal conviction as well. Committed an act outraging public decency by behaving in an indecent manner, and the penalty was evasion. You can see that all those that had criminal convictions end up being removed from the register. The same thing applies in Nigeria. And this shows that you have to be careful of criminal acts. If you're involved in a criminal act, you could face erasure from the register. Then there's architect Mr. Anthony. Was disqualified from acting as a company director as of 12 September, failed to report to the architect return report that he was the director of M&B Accident and was wound up on 9th March 2015. And he was disqualified from acting as a company director from 12 September to 2016. Penalty, 2 years suspension. Let me explain this case carefully. He had been removed as a director from that company, but he continued to operate as if he was and never reported to the accreditation board. And for that, he faced a 2-year suspension. If you registered an architectural firm, and by one means or the other, you have left that firm as a director, a shareholder, CAC document has been processed, you have submitted, your board registration was done, and you have changed your documentation in CAC, you are bound to report it to the Architects Registration Council of Nigeria. You know, when registering a firm, you first register the entity as, an enterprise or a limited liability company with the company under the Company Allied Matters Act at the Corporate Affairs Commission. You now bring that document to the Accreditation Council registered as an architectural firm. Now, if you go backwards to CAC and change your qualifications there, you are bound to report it back to ACON. If you do not, it is also a criminal offense because you have falsified information. You have misrepresented yourself to the regulatory body. So you cannot create firms and then walk away from them. Devolve yourself legally, but leave them on the ACON register. They become offenses. Now, architect means IT. Nature of the offense is of becoming professional conduct. Fail to provide a complainant with any adequate explanation for non-payment and an update of her financial position. Fail to inform the accreditation board that she failed to pay a judgment debt. Failed adequately at all to disclose in writing to the complainants that in acting as both an architect and a contractor, her advice would not longer be impartial, or there was a conflict of interest, or given a conflict of potential conflict of interest, she required the right to written confirmation from the contract, giving informed consent to the respondent, continuing to act. The penalty was illegal. Let me explain this kind of legal terminology in plain English. A complainant is probably the client did not explain non-payment of her financial position, maybe her registration fees with ARB. Failed to pay a judgment debt. That means she had been charged that she was owing somebody and she ought to have paid that debt. she did not pay it. So if you owe the rent, someone took you to court, they get judgment against you, and you don't pay that debt, you'll be in a position to lose your license. That's what it means. Because you've already been convicted, except you are appealing the case. So why is an appeal? Yes. But if it's a judgment that is being enforced and you have absconded from paying, that person could come after your license. And that's what really happened to her. She also acted as both an architect and a contractor and didn't inform her clients that there will be an issue of impartiality involved, which is a conflict. And all is added together to have been erased from the register. If you are acting as an architect and a contractor, please notify your client. Do not hide facts from them. Do not act as an architect and you are secretly acting as a supplier and paying yourself. People have done this in the past. I've had a case of a client who complained to the regulatory body at one point in time and was explaining to me personally that he employed an architect who was personally using his position to enrich himself and buying things as if he was both the architect and the supplier. It's wrong. And at one point, some of us also make the mistake of procuring approval plans for our clients and charging them fees in the impression that we are paying those fees to the planning authority. Meanwhile, we are making money off it. We also need to be careful. We need to disclose. If you're doing a service to a client, make sure he knows you are the one carrying out these services. You are not using a third. The last case I'll bring up is M. Christopher. Yeah. He failed to deal appropriately with a complaint in that he failed to consider demand to refund an overpayment to his clients. Very rare incidents. Failed to ensure that the website of the practice promotes its professional service in a truthful and responsible manner. Acted without integrity by inappropriately suggesting in letter to the board that you would only return the money overpaid to me if the complainant agreed to withdraw the complaint from the board. He failed to account or has delayed in accounting to his client in respect of monies she had overpaid to him. He failed to cooperate fully and promptly with the board's inquiries in that he failed to provide evidence to the board that he retained money in a separate client account. All these are financial improprieties. And he ended up with a penalty of erasure from the register. So you need to be truthful and responsible to your clients. I've had a case of having to refund money to a client on a particular project that we said could not be done. And he was owing another project, but we refunded the money and said, look, this is for this project. This other project you are owing us on it. We did not mix the two together because he could report. Clients have the right to report you to the regulatory body if they find any issues with you, any issues with your services, any issue with finance. So you need to be upfront. Keep a good register of accounts. How much money you collected from your clients, how much you executed on project. Give an update, an accounting of all the resources you have executed on the project, especially when these funds are passed to you. If they're not passed to you, yes, whoever is the conduit of those funds has to keep good account. I want to summarize by concluding by saying, keeping out of trouble requires a detailed knowledge of the laws of the land, not just those that affect professional practice and contract administration. It's these unknown areas that often trip wires to trouble-free professional careers. And when in doubt, get legal counsel. It's very, very important. And at all times, you do that, you will not infringe on any of the laws. I would like to say thank you for listening to me. We've gone through quite a lot. I would ask them to send links of where I've gotten these laws of Nigeria, and you can check them directly online, and you can choose the laws that relate to whatever projects you're working on. Please do that consistently. If you're working with a parastatal, check the laws that enact them. It might help give you information on how to work with them. If you're working with an agency, check the laws. There might be one or two clauses that relate to your relationship with them. So thank you, and keep out of trouble. Thank you very much.
Thank you very much, sir. We appreciate that robust conversation we just had. Wow. Basically, summary of it is having a detailed knowledge of the laws of the land, not just the, as it were, micro laws that govern your professional practice, but actually that which embodies the laws of the land. Wow, awesome conversation, quite instructive, quite insightful. I mean, look, there's a saying that says, the saying which goes like this, that without the law, the people are loose, they go wild. And you know, the essence of us being professionals is that we are bounded and guided by laws. We are guided by principles, you know, that are in tandem with the laws of the land, principles with our own professional bodies, and also which are in tandem with the laws of the land. At this point, I want to thank you very much, Architect Ladi Luis. Now, our participants, you understand why I call him the Asiwaju of architecture. I mean, on any topic, you can rely on him to do a yeoman's job. I mean, he's one egghead I always want to have around me. I mean, not just for webinars, but even consult. He's my chairman. Well, that is, if you know, you know. Yeah? He's my chairman there. Thank you so much, sir. Thank you so much. You can see the accolades coming in here. He's a great mentor, definitely. That's Rotimi Ajayi saying that. Thank you, sir, for your insightful lecture. That's from Uche Anoilifo. Thank you very much, Architect Ladi. Any day you are top, sir. Yeah. Thank you so much, participant. I'm sure we are all, I must always say that we are all blessed. Can you imagine? I'm sure we are all very much impacted. All very much impacted. At this point, this is the Q&A session. While the Q&A session is up and running right now, Francis, I want you to post the link just in case. This is just in case you've not uploaded your evidence of payment, which will also capture your detail, your name, your license number, your account registration number, your phone number, your email. This list is an auto-generated spreadsheet that will be forwarded to the Account CPD board for your requisite scoring points for this webinar. So just in case you've not done that, the link to upload your payment detail and capture your details, your information to earn your CPD point will be posted on the chat box there, just in case you've not done that. Architect Ladi, thank you once again. At this point in time, if you have any question, just with the electronic wave of the hand, please just raise your hand if you have any question. I know it has been very explicit. That has been the hallmark of all our guest speakers, very explicit, very fluid and lucid. There's no gainsaying about their conversation. It's always very, very, very explicit and well with so much on the profound understanding. So at this point, if anybody has a question, comment, there's a question. Okay, Francis, could you just take that for us? Question.
Okay, sir. The question goes this way now. architects change dimensions on science plans so we can get approvals on building plans. How does it come as an
because you have tampered with a survey plan, most likely. If not, you've tampered with your own site plans and you misrepresented a document that is going to be used to get a government approval. If you remember, under the laws, we are talking of procuring something from government using false information. So you falsified information. Now, the states to which you presented that approval, if it's to the state government, have their state laws. You would have to look under the state laws, but it likely would follow what the federal law says. First, your approval will be cancelled. That's number one. Number two, you could be charged for misrepresentation, for having falsified a document, which is actually a forgery, and that could also attract a jail term. So doing it and getting away with it is because people have turned a blind eye to what you've done. Please be very, very, very careful about it. It will have an impact on your career as an architect. You may not know the consequence until your documents are checked and they find out that you have manipulated such documents. As if you know that your approved plan is going to end up having government seals and stamps on them. So they become documents of the state as well, because it's expected that those documents have gone through a process where public safety has been evaluated. But your change of dimensions may put the public at risk. So imagine if there was an accident on that project, maybe it's no fault of yours, but the documents are not scrutinized, only to discover that what was on ground is not what is in your documents. So you could be held responsible and liable for forgery and falsifying documents to procure a government approval. So I think there's another question.
Okay. What if, as an architect, you doubt the engagement of registered professionals on a construction site? Do you have a coverage to enter the site and verify this by asking questions for possible reports to the regulator and government agency?
First and foremost, yes, we're a citizen. We've had people talking about citizens' arrest, but where I am found out in law, what we can do is to report to the government agency and make a complaint. You can't be a policeman. You can't be an investigator. That duty has been given to the physical planning authority. And you can make a complaint to them about any project that you see going on, that you have doubts about. And that will be your duty. If there is a criminal act going on, you can go to the police and report. Oh, somebody is doing this, somebody is doing that. It's a criminal offense. So you need to be sure of your facts. The police will do their investigation and find out whether it's true or not. I can give you an example of where a gentleman next door to my office had a very noisy generator. It would give you headaches. And we complained and complained and complained. We wrote letters and he did nothing. So I walked up to the police station and said, he's constituting a nuisance under the environmental laws. And the police came to the premises, looked at the generator, videoed it and recorded the noise, and invited him to the police station. When it occurred on a Friday, which was a very motivational day for anybody who's been invited to the police station, as you know, he didn't want to stay there till Monday. So he quickly put up the generator. And this generator is so bad that when you switch it off, it takes about 45 minutes for the sound to wind down because the engine is still running and has to use its own momentum to wind down. But what you can see is that we didn't go there to cause a fight. We didn't go there to try and enforce anything ourselves. We simply just reported. So you can simply report, and you are allowed to make a report. And even a lot of advocacy groups who now are involved in looking at projects and making observations and reporting. But you also have to be careful that you are not found to be defaming someone. So be sure of your facts that something is wrong there before you make a report that could affect somebody's integrity or their credibility in society. I hope I answered that question. Are there any other questions?
He said, look at the last. There's one that says you have to be mistaken, however, and no observable case cited from Nigeria. Do you have any registered cases? You need to read that loud.
Okay. Good afternoon, and thank you, sir, for the presentation. I may be mistaken. However, I did not observe any case cited from Nigeria. Do we have any registered case or cases in Nigeria?
There are a lot of registered cases. We do not publicize those cases, but I'm aware of quite a lot of cases that have been dealt with by the Accreditation Council of Nigeria, and some cases in courts too as well. And I've heard of cases that have been reported. And while I was chairman of the institute, I've had some cases that have been brought to me that I had to pass on to the National Institute, that will now pass it on to the regulatory body. And I've heard of individuals who have by themselves gone to the regulatory body to make complaints. So there are definitely a lot of Nigerian cases. And you also, if you find a problem, can make a case too as well. Now, there's another question. A client wanted me to increase the site plan for a school design so that the land can contain the design appropriate for approval. What's the ideal step to address the issue? Knowing that I was not the initial architect. Increase the site plan, meaning that you are going to falsify the site plan. That means you are co-conspiring with the client to fake the site plan for approval. And you are going to be a primary will I say, instigator of that action, because you are the one producing the site plan. He is going to be an accessory to it because he's asked you to do it. So you cannot falsify documents. It's a common thing in architecture that I've noticed, people falsifying documents because they believe that they are just drawings. But these drawings are going to be used to procure government approval. And these are documents that will become legal documents. They will be looked at for years to come. You need to be very, very, very careful. It's a forgery. That's what you've done. If you are increasing anything and it's not true, it's not what is on ground, you are being deceptive. It's not, you see, we assume we are just, like we said initially, the euphoria of just doing a design, we just keep on designing, we create all kinds of things. But they also have legal implications. It will result in a dispute on the land tomorrow if the thing is plotted and somehow the documents find themselves in the hands of some other people. So please be very, very careful.
How can you be sure without asking questions from the owners or participants in the process without overtly causing problems when doing so?
I think you're relating to the issue of this same, your client asking you to do certain things. You have to be open. You might have to walk away from some projects because you don't want to be implicated in a crime. You might have to.
What if the client has provided the survey plan without your knowledge of it being the true representation of the facts on ground?
Now, if your client provides a survey plan, the onus is on you to also check and verify, because you could be involved in a dispute. Yes, you might be found not to have, because the obligation is on the client to provide you with a survey plan. Provide, that's what the law says, he's supposed to provide you with such document. For you to also do your background check, you can do on Google Earth, Google Maps to verify some of these things. And you could do your own physical measurements too as well. You need to be careful about these things so that you do not get involved in a tortuous court case. If you be involved in court case and you know they can last for years, they will take up your time and your effort. As I always said, staying out of trouble is better than getting out of it. So you need to avoid falling into trouble. You are safer than getting into it.
So, on the issue of changing of dimension, in this case, a reduction of cantilever, for instance, after approval drawings, what is the place of amendment or variation, which may be essential, and what is the place of as-built drawings upon completion of the project?
Normally during construction, we always say that there will always be amendments and things like that. You need to document those amendments or variations. And you might need to furnish the building control agency with those changes. So that's why sometimes you have as-built drawings and they come around to verify what you built on site. There is a famous housing estate that you probably might see even in some Hollywood movies. I've forgotten the name of this. It was a very popular terrace housing estate. And in the estate, while it was being built, when they were putting up the foundation, they found that there was an underground leak and they had to vary their designs for it. It cost, as at that time, somewhere in the 70s, over some millions of pounds of variation, but they had to make those amendments. And even in our standard forms of building contract, substructure is provisional because you don't know what is on the ground. So that could affect your project as well. So you need to document whatever changes are there and make sure every consultant signs up on it. And you let the planning authority know, yes, we've had to make a change on our design as well, and we'll continue. And once you can defend those changes, you are protected by the law. So present the facts, do not hide them.
All right, thank you, sir. Sir, is it an offense if a client decides not to continue with the initial architect and he invites me as a new architect to continue the project? What is my offense with the old architect under the law?
Well, you've asked two questions. It says, is it an offense if a client decides not to continue initial architect? It's not an offense. He has to pay off the first architect, settle all financial claims to that architect, then he can continue with anybody. If he has paid for the work, then he can use the work. If he has not, then he cannot. And the new architect has to confirm with the first architect that he has no claims, he has no lien on the project, and then he can continue. There have been cases where the contract is that we're going to pay you for your design and we're going to use your design, but we will use it at our own discretion. So it depends on the contract you have with the client. It could be a competition project and you're going to be paid off and the client is going to own your design. So if you are agreeable to it, then so be it. The city center in Las Vegas, on the project, they employed 5 urban designers and they all produced their urban design concept for the project, the architectural firms and urban designers. And the client took the 5 different proposals and picked the best parts of each of the projects and combined it under the coordination of one of the urban designers. And they paid each urban design firm $500,000 to earn the rights to that proposal and use it as they wished. So it depends on your relationship. As far as there are no other financial obligations outstanding to whoever was initial architect, which is covered under the area of supplanting.
Okay, thank you very much, sir. Do we have instances where states or institution grant waivers on existing laws bordering on approval? But if a party instigates an action, what liability does the architect has?
Now, you're saying where a state or institution grants waivers on existing laws bordering on approval. Now, but if a party instigates an action, what liability does the architect have? The party will be instigating the action against the state because they granted the waiver for approval, not the architect. So if the state decides to grant a waiver and says, look, we are accelerating the approval process, we're doing this, it's the state. They own the law, but they have to also conform to lay down procedures. I know, for instance, now that practically in Lagos, even if you're a parastatal or whatever, you're an agency, you still have to go through the approval process. This was not the case before. But it's not, even government itself and its institutions now have to go through an approval process. So they are tightening the rules on those kind of waivers where projects simply just get built without approvals being in place.
Sir, can we have practical examples when an architect can sue a client to the court and stages of doing so?
You are free if you have any complaint about a client. First and foremost is that if a client owes you, you are under no obligation not to sue. You can't sue to claim your money. You can go to arbitration, you can go for mediation, you can go for an out-of-court settlement, you can claim for your money and you can go to court for it. Most of the cases, that's probably one of the issues an architect will take his client to court. And you are obligated to recover your money from the client. But you see, you have to go through the process of making sure that you have your documentation in place to keep track of the communication between yourself and the client. Clients can be very, very evasive when it comes to acknowledging documentation. Try as much as possible to make sure that they receive it. And in one way or the other, you get acknowledgement. And always make sure you keep documents, keep track of them. Make sure that every little thing you respond to your client's communication. And I always tell people that, look, you will have to go through a series of clients and find those that you can work with. There are some clients you may never be able to work with. No matter what you do, they are going to shaft you. And you will see that they have a reputation. You will not be the first architect and you will be the last who have that experience.
Thank you very much, sir. Please, what is the place of informal relationship on project supervision when the client, in this case an institution, expressly states, although not formally requested, that they don't want consultant team to supervise construction, but often plead on the architect to visit project sites? Kindly advise.
A very dangerous move at times. The truth is this: are you planning for free? That's number one. Number two, it could have implications because you don't have control over the project site. You are simply just working there to take a look and move on. But you could be used as a reference when things go wrong. Now, you do not have any communication or relationship with the contract. As you know, when you're signing contracts, a contract is signed between the client and the contractor, and you are the witness, you are the arbiter between it. So in that contract between the client and the contractor, there is a provision for you to sign as the architect who is engaged in stage 3 process. And I always tell people, avoid using the word supervision at stage 3. You are actually inspectors. When you go to court and you use the word supervision, it means you are there 24/7. You supervise your construction drawings, but you inspect the works on site to conform to the drawings and documentation you are giving the contract. So we were discussing about stage 3. Stage 3 is always probably one of the most contested areas in terms of your relationship. Now, there's a question that is for client between supervision and stage 3, especially as a consultant. I always tell people that studying contract agreements done by older professional bodies, they have carefully over time studied case law as relating to stage 3. And they call stage 3 inspection because you go there frequently and occasionally, as the case may be. You are not there constantly. When you're a supervisor on site, you are there 24/7 to supervise the work. You are in your office supervising your drawings with your architects and supervising the production documentation for your projects. But on site, you are practically inspecting the works. So while inspecting, you also need to watch your liability on that project. So I had to tell a client once who was saying, oh, the contractor has not done this, has not done that, has not done that. And I said, yes, the contractor ought to do A, B, C, D, and E, and we reported it already. So he said, how do we get him to do it? I said, well, we write and we withhold payments. That's the only powers you have as an architect. You hold payments, and based on the contract, and you effect any liquidated ascertained damages to the contractor. He has the insurances, performance bonds, advance payments guarantees to protect the client. So your documentation is what you use. You as an architect in the university when you were in your training, you are not taught how to put a nail in the wall. It was not part of the course. I don't know who took that as a course, how to put a nail in a piece of wood on site, and was trained in architecture school. You are trained to design. We tell a lot of architects that. So I had to tell the client once, I said, I can't put a nail in any piece of wood on your site. That was not my training. That is the job of the contractor. But I'm there to inspect that the final output meets our design requirements. So be careful about stage 3. The next part of our presentation will look at that stage 3 and that aspect of the actual contract process. What we've looked at today is the criminal parts. Majority of what you do on site will be civil issues. So the civil issues are minor, but they will also result in you facing professional misconduct as an architect. So it also has penalties. What we looked at are the criminal aspects that will affect you today, but we'll also be looking at the civil aspects that have to deal with your practice as an architect. There's another question: when a contractor could meet up a production date and was going to do an extension, does the architect get paid for the extra time? Yes, in the conditions of engagement, your stage 3 should be on man hours, time charges. Stage 1 and 2, that is pre-contract, can be on a lump sum, but stage 3 should be on man hours. So if there's an extension of time, you already factored your payments for doing that. If not, you are going to shortchange yourself at the end of the day. So if you calculate your stage 3 based on a lump sum, you are seriously in trouble. So check the Architects Accreditation Council conditions of engagement for architectural firms and architects. It will guide you on how to charge for the stage 3 and deal with extensions of time. Any other question?
There's someone's hand, so
Okay.
there's a hand that's that's the hand that is up.
There's a hand up.
There's a hand up in front of you. There is a hand up. Okay, I think the hand is down. Okay, we're back there. All right. Okay. At this point, I think Francis, could you kindly check the chat box? Any other question there? Most public projects are still calculated based on the 1996 scale of fees and requires the architect to still be on the job after exceeding the time for the project. What can be done here? That's Shakiruddin Yusuf.
Yes, as I've mentioned that even in the 1996 scale of fees is used, once the contract period ends, you are supposed to calculate your fees based on the old man-month rate. It's there, even in the 1996 scale of fees. And the contract period has already been defined. Initiation of contract, completion date. Any additions after that, only even in the 1996 scale of fees, is based on the man-month rate.
Okay, sir. If stage 3 is on residency basis with an on-site architect and the senior architect backstopping does inspection still stand instead of supervision?
I would like to ask this question. I will start with this answer. The architect on site, what is he supervising? You are actually saying he's supervising the installation of or the execution of your architectural drawings on site. He's not supervising the construction works. So even as a resident on site, he's just available to inspect what is going on a constant basis, more than you would have if you were not resident on site. So it's available. So what happens with the resident architect? What is his job? He's available to the contractor to look at the drawings, to explain what they are. Because what do you do during inspection? You look at the work. So it's not a supervision. A supervision means he has overall control of the process. So if he stays he's supervising the tiling, then he's charged with the selection of the tiles. He's charged with how the mortar is mixed. He's not. He wasn't trained for that. He was trained to design and to observe the execution of the design on site that is done according to what was designed for. And it's always the end product. It's always the end product that you check. And that's why there's a condition in the contract for opening up in case somewhere has been covered and you doubt that the work was done appropriately. You are allowed to ask for an area to be opened up to check that the appropriate thing was done. So your residency does not take over the contractor's supervisory role. His role to have construction managers, foremen. He will have supervisors for his carpentry team, supervisors for his tiling, masonry, concrete mixing team, his plumbing team will all have supervisors. He will have tradesmen. These are the people that actually supervise the construction. But you as a resident, you are there to answer questions on your drawings. You can't, in the US, the contract agreement does not allow you to even tell the contractor how to execute his work, because it could make you liable for any processes he undertakes that goes wrong. So we actually needed to do a lot more work on contract administration processes. I always like to talk about the AIA contract management documents software that they have. They have been producing construction agreements and documents since 1888. We have a suite of over 200 agreements for every form of procurement you can think of. There is a series of agreements for every party in the project, covering every aspect. They have a standard performance bond. So you have agreements. You have agreements for every form of procurement process. You have agreements for every form of the process. So everybody is covered on an agreement and process of how to execute the contract. So there are subcontractor and main contractors agreements, tying them to the appropriate process of work. All liabilities are documented and prepared for everybody. So you know what processes are being run on site. Nothing is left to chance or guesswork. Yeah, I think we should one day do a series on that and see how we can integrate this into our contract processes in Nigeria, how we can make our contract agreements much more efficient, and that will guide us. And we'll cover up all these questions we're raising.
So, as a follow-up to the question you are answering at the moment, the person said, but the architect under the JCT to prescribe the method of executing his design, can this be termed inspection, specification, or supervisory?
Now, the method of execution of your design is that, look, we want a project built in concrete. We want a project built in block work. We want a project built with steel. Yes, but there are other detailed processes that the contractor will go through. I'm sure you may not have heard of top-down construction. The contractor could recommend that to you when doing a business. There are very complex shoring processes that might be required. Retaining wall processes that might be required. Scaffolding and all those intricate things. They are beyond that scope of the architectural services. They fall in the purview of an experienced contractor. If you go into certain areas of construction that you do not have the experience or the staff or the manpower to handle, you could actually be taking over undue liability. Formwork design is a very complex and specialized field. So is even scaffolding. And I can tell you that in the UK and in the US, you need a license to set up scaffolding. You need to have been trained and to get a license to set up scaffolding. So if you're taking up construction methodologies and processes, you need to have the experience. And when you're evaluating contractors, as you recall, you evaluate them based on their experience, their manpower, their tools, machinery, and equipment, their supervisory capacity. You can't compete with that as an architect. So you need to know when something is beyond your scope of services, and you allow those who have been trained, who have been prepared to carry it out to do it.
Thank you, sir. What is ACON doing about lecturers assaulting students by slapping, kicking, or flogging them with regards to the state laws?
The first answer I would give is that before it comes to even ACON, somebody has violated your rights. this will be termed as assault. So you report to the police. It's as simple as that. You don't need to go to ACON. You report to the police a criminal offense. When he has been charged to court and convicted, then he will lose his license with ACON. You see, there are certain laws that supersede others, and you have to remember that this is assault. You cannot physically assault anyone. So you report to the police immediately. In fact, it's even beyond the school authority because it's physical harm. It's under the criminal code. It's there already. So you report to the police, you'll be arrested, you'll be charged to court. And then if he's convicted, then ACON will now take it up that, look, if he's a licensed architect, he will struck off the register because that's what the law says.
There's a scenario whereby the client who is an accounting institution removed over 10% for VAT instead of 7.5. The architect consultants raised for clarity, but still not clear enough. Sir, what is your suggestion in this situation?
It's very simple. Get the act on VAT. Get the act on VAT and send it to your client. If he has inappropriately done that, he's committing an offense. If he's charging 10% when it is 7.5%, he's committing an offense and he can be charged to court. That's what the law says. You cannot falsify a government edict. If government says VAT is 7.5%, he cannot charge 10%.
Secondly, sir, where does the VAT go to? State or federal government?
I hope you know there is a court case that has been, I think, is either in process or has been one where the states are now claiming VAT. That is no longer the federal government. So we are yet to see where these payments will go at the end of the day. But make sure that you put those things in place and you document them so that when you are asked to remit your VAT, you remit it appropriately. So, is there any other question?
All right, I think we have exhausted not just our time here, but also the bandwidth of the guest speaker. He has done exceedingly abundantly well in delivering this masterpiece lecture this afternoon. Architect Larry, I can't thank you enough. Thank you so much. We appreciate your time, out of work time. Excuse me, let me just mute off. Well, we thank you. Well, we're just trying to mute there. Please, 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 yet again, all mics should be muted except that of the guest speaker and the moderator. Thank you very much. We are wrapping up now. Architect Ladi, thank you so much for the excellent and brilliant lecture. We appreciate your support always and willingness to always be in terms of information dissemination and impacting your generation. Now you see that this title wasn't ordinary. When I called you the Asiwaju of architecture in Nigeria, well, I have been justified. I have been vindicated. I cannot be sued. So it is what it is. Thank you so much, Agladi. Thank you, Francis. Thank you, Amani. And to wrap up, I can see our BOT chairman is in the house. Architect Justus of Vae, the big masquerade of in the anchor is in the house. Sir, if you will just unmute, let me see, where is he? Yeah, I can see him. I've asked you to unmute, sir. I'm making you co-host, sir. Kindly unmute yourself, sir. I've asked you to unmute yourself, sir. Architect Justus Okaobaya, kindly give us the vote of thanks and wrap up on this. Lend your voice to this conversation and wrap up for us, sir. Thank you, sir. Architect Justus Okaobaya.
Thank you, Boduri. I'm happy to be here again, and I trust Ladi Lewis any day. And all our resource persons are always very fluent and lucid and well. They present very well researched topics, and I'm grateful to him and all others. Thanks everybody who is in the house. I think I will leave every other thing for the president to say if he has anything to say. Thank you very much.
Thank you so much, sir. I appreciate you. It's good to hear your voice again. I am encouraged. Thank you very much, sir. Thank you. Pianka, sir. Well, you just had BOT chairman say you leave everything. He said he leaves everything to the president to wrap up. So based on what you told me earlier on, that has been overruled. So you have to speak, sir. So please, where is our president? I can see, I've asked you to unmute, sir. Asked to unmute. Architect Monoyoren Emmanuel Otis Omasone, the national president, Association of Nigerian Chartered Architects. You have the floor, sir. Thank you, sir.
The PRO, thank you very much. Ladi has delivered everything about the lecture he wants to deliver, and the BOT chair has given the unqualified appreciation of ANCA. I cannot talk after the BOT chair has spoken. So that I would not be flouting the protocol laws like Ladi has been telling us. The flouting of any law is the flouting of the law. Who no go know. Who knows it. BOT chair, thank you very much for giving us the opportunity to serve ANCA. I thank everybody for the cooperation, and most importantly, Ladi, as usual, top notch. Very well, you've done us very proud. Thank you, God bless. ANCA Dede, one and all.
Thank you very much, sir. I appreciate that you finally lent your voice against the backdrop of what you told me behind the scene. If you know, you know. Well, you said who no go know, now you know. You get it. If you don't get it, forget it. There you have it. Thank you so much. All right, to all our participants, I want to thank you because I think the signals at the broadcast center here is that we need to shut down right now. Thank you all so much for being part of this conversation. It has been a very impactful, insightful, instructive session. And there you have it, the tripwires that could negatively affect your practice as an architect in the course of executing or doing your job as an architect. There you have it. Please, you can relive this experience on our YouTube channel, ANCA Architects. Just go to YouTube channel, type in ANCA Architects. While you are there, like our channel, subscribe to our channel. It's a compendium of webinars, of talks, of lectures we've had so far. You can go there, spend time to relive the experience, to just have that, refresh yourself with the conversations that have ensued thus far till date. Well, my name is Bodri Obutoye, the National PRO of Association of Nigerian Chartered Architects. Thanking you all, thanking the BOT chairman for giving us the privilege and the honor to serve on this platform of ANCA, and also the president, Emmanuel Omasone, Architect Emmanuel Omasone. They're always very supportive, always having that fatherly oversight, always having that when the head is hot, is the one who's cooling it down. Thank you so much, sir. I appreciate you. And like I said, my name is Bodri Obutoye, and I approve of this conversation, the architect and the laws of the Federal Republic of Nigeria guide to keeping out of trouble. I'm signing out here, saying God bless. Thank you. See you soon. let me just quickly let a little cat out of the bag. If all things and it is going that way, if all things being equal, we are going to actually have a physical facility tour to one of the top product and service providers in the paint industry in Lagos. I'm also asking them, pushing for virtual participation. We are working on it. We are working behind the curtains on it, and it's a yes, we're almost good to go. So just stay tuned to all the Anchor, Association of Nigerian Chartered Architects platform, WhatsApp group, Telegram group. If you are not there, join in, sign in. Our social media handles on Facebook, LinkedIn. Where is that too? We are also on Instagram. We're all out there on the social medias. Make sure you follow us. Make sure you're there. Don't miss out. Anchor is about impact. Anchor is about progress. Anchor is about productivity. Anchor is about being the pillar of excellence in all things, in all ramifications, on all fronts. Thank you very much. God bless you. We're signing out of here. We're done. Thank you. Right, let me play my music.
you.